ready for the dictation? Start. Reliance is also placed by Mr. Nath on the judgment by Karnataka High Court titled PM Parameshwar Murthy versus State of Karnataka WP number 4340/2012 decided on 21/11/2012. On the other hand, Mr. Chopra, learned counsel appearing for respondent number 2, submits that the allegations made and contentions raised against respondent number 2 are unfounded, baseless, and are required to be rejected. Counsel explains that respondent number 2 did not increase the marks of any candidate, although he awarded grade B instead of grade D by inadvertence. However, by an order dated 12/5/2009, his explanation was accepted, a copy whereof has been placed on record at page 556. Thus, this matter cannot be taken as the reason for his disqualification. Regarding registration of a CBI case against respondent number 2, Mr. Chopra submits that the case was registered against the director of AICTE and respondent number 2 along with other members of the team. Mr. Chopra submits that a matter of fact, the CBI did not proceed against respondent number 2 and only recommended disciplinary action against him, pursuant to which a so-cause notice was issued, a reply was filed, and the explanation was accepted, laying the matter to rest. Even the accused persons in the CBI case stand acquitted by an order dated 6/1/2016, a copy of which has been handed over in court, and counsel has been directed to have the same placed on record. As far as the show cause notice issued by the executive council is concerned, a censure was issued which was challenged by filing a writ petition in which the court has stayed the order of censure. Further, as far as debarment by AICTE is concerned, Mr. Chopra submits that respondent number 2 was not informed of the same, and it was only after the filing of the writ petition that respondent number 2 wrote to the AICTE, and she has placed reliance on the reply dated 28/2/2019 received by the AICTE. Mr. Chopra submits that despite the so-called debarment, the AICTE continued to appoint respondent number 2 in various departments, and as such the debarment was not acted upon. Reliance is also placed on the document at page 708. Mr. Chopra contends that the allegations of being guilty of plagiarism cannot be urged for the reason that the works were neither stolen nor copied, and in the work of respondent number 2 due reference was given to the work of which extracts were quoted, and moreover the person whose work was used has not made any grievance. Regarding the plea of the appointment being contrary to the UGC guidelines of 2018, counsel for respondent number 2 submits that the guidelines would not apply as respondent number 1 is not an aided institution. We have heard the learned counsels for the parties and have considered their submissions. As we have stated in paragraphs 4 and 5 foregoing, the substantive ground raised by counsel for the petitioner is the issue under section 46 of the Act, which requires consideration and would be examined at the time of final hearing of the writ petition. However, at present, we are not hearing the petition on merits but are only considering the application for grant of interim relief. We find that the various allegations made by the petitioner have been satisfactorily responded to by Ms. Chopra, learned counsel for respondent number 2, by placing reliance on several documents placed on record. It has been clarified that the AICTE debarment of 3 years was restricted. Further, as far as the CBI case is concerned, the case was registered by the CBI against the director of AICTE and respondent number 2 along with other members of the team, but the CBI only recommended disciplinary action against respondent number 2. Pursuant to that, a show cause notice was issued and an order of censure was passed. The order of censure has been challenged by filing a writ petition and the order of censure has been stayed by this court. As far as the allegation of plagiarism is concerned, a satisfactory response has been given by Ms. Chopra that there is no complaint received against respondent number 2 by the author/owner of the work. With regard to debarment by AICTE, respondent number 2 has, despite such debarment, been appointed by AICTE in various departments. While the issue of the appointment of respondent number 2 on an interpretation of section 46 is yet to be considered at the time of final hearing of the writ petition. At this stage, on a prima facie examination of the matter, we are not inclined to grant any relief to the petitioner. Stop.